afternoon. I'm recording this a few days earlier because I'm unable to attend the conference. I'm sorry about that. The competitive process standard is not a new idea, but my article in Antitrust Law Journal may be its first full exposition. The basic idea of the competitive process standard is very simply that antitrust law focuses on the process of competition. And this contrasts with the consumer welfare standard, which holds that antitrust law focuses instead on market outcomes. To explain the difference, I like to use the old structure conduct performance paradigm, which was developed by industrial organization economists to identify and categorize the forces and factors of interest to them. The paradigm depicts market performance as a result of market structure and market conduct. The competitive process standard focuses on structure and conduct. In contrast, the consumer welfare standard focuses on that last step, performance. The competitive process standard is a general decision rule for cases. It is a rationale for specific legal rules, and it is an overarching policy guide. The competitive process standard is fundamentally an expression of faith in markets to produce good performance. And it is an expression of the absence of faith in the legal system to fine-tune markets in pursuit of better performance. My advocacy of the competitive process standard goes back decades. On numerous occasions, while working at the Department of Justice, I saw the consumer welfare standard more as a problem than as a solution. The consumer welfare standard has been described in many ways. It's often been described as a decision rule for cases, but sometimes it's been described as a rationale for specific legal rules, or even just as an overarching policy guide. Depending on who's advocating it, the consumer welfare standard has referred to the welfare of different consumers. It has referred to the welfare of the buyers in the relevant market, the welfare of both the buyers and the sellers in the relevant market, the welfare of either the buyers or the sellers in the relevant market, or the welfare of the consumers at the end of the distribution chain. Robert Bork initially advocated the consumer welfare standard merely as a rhetorical device. He was ridiculing the unprincipled decision-making he saw in some court decisions. Now, later in his book, he went much further. He attacked what amounts to the competitive process standard. He argued that the word competition was ambiguous and that it was being used by judges in antitrust decisions in a variety of distinct ways. He proceeded to argue that each of 5 possible meanings was unworkable as a guide to antitrust law. He concluded that the best way to think of competition is as the salutary economic results we expect to get from competition. Bork did not consider the concept of competitive process, and he did not seem to understand the concept of rivalry. Bizarrely, in my view, he equated rivalry with the number of rivals, but that's not the way the word is usually used or understood. He seemed unaware that there can be intense rivalries between just 2 rivals, but he should have been aware that there was an intense rivalry between Yale and Harvard, both in football and in law schools. One reason I wrote my article when I did was that at that time, the heads of the 2 federal antitrust enforcement agencies were both attacking the consumer welfare standard and talking about the competitive process. But they didn't explain what focusing on the competitive process would entail. So I decided to try to explain that. Another reason I took so long to get around to writing the article is that I took a long time to fully appreciate the necessity of the competitive process standard. I appreciated that only when I wrote my book after retirement, and I decided to address the constitutional attacks on criminal Sherman Act enforcement. In writing my article, I needed a term for the core per se rule on which Sherman Act criminal cases rely. What I settled on was the mother per se rule. The editors at the Antitrust Law Journal didn't like that, but I stuck with it because I needed a term and I liked that one. Sorry. But the mother per se rule is the rule that declares that price fixing, bid rigging, and customer or market allocation are unlawful without regard to market impact or justification. Now, what I came to realize working at the Department of Justice is that many antitrust lawyers don't appreciate that the rationale of the mother per se rule is vitally important to the constitutionality of prosecutions based on it. The folks in the appellate section at the Antitrust Division that defend these cases in the Courts of Appeals are the only ones I ever work with who completely understand this. The mother per se rule is often misdescribed as a presumption of tangible effects, and that those effects themselves are an element of the offense. That means presuming an element of the offense, which is problematic because there's plenty of law that says you can't do that. But this is the wrong understanding because the Sherman Act is about the process of competition and not about its tangible results. Critically, the mother per se rule also is not a substantive rule of law that the Supreme Court simply declared. Under the Constitution, the Congress has the exclusive power to declare a crime. To make criminal antitrust enforcement constitutional, we must read the text of the Sherman Act to imply the mother per se rule. And that's precisely what the courts did in the early decades of the Sherman Act. They didn't call it the per se rule, but they did say price fixing was unlawful under the Sherman Act and could not be justified. I view the mother per se rule as the beating heart of antitrust law, and it is unfathomable to me that the beating heart of antitrust does not share the same DNA as the rest of the body. It all must be about the competitive process, and my article tries to explain what that means as I see it. One thing it means is that we should not be preoccupied in antitrust with output. Now, output typically, although certainly not always, is a good proxy for welfare. But it's often infeasible to use it as a proxy for welfare because we can't really sufficiently ascertain what output effects exist. If plaintiffs have to prove these effects, they simply can't win, even when they have sound cases. And this brings me to the final reason for the timing of my article, which was the American Express decision. I view that decision as the ultimate triumph of the consumer welfare standard over common sense. Harm to competition on the merchant side of the market was clear and profound. The restraint was designed to make output unresponsive to price, and it worked. Price competition was reduced to the point of irrelevancy, but the Supreme Court was unmoved. In my view, the Supreme Court lost the threat of antitrust law by ruling that eliminating price competition need not be justified in any way when it is done in certain settings. I think the court harmed consumers, but that is hard to prove. My article explains how process harm is proved in distinct types of antitrust cases. The proof begins with a narrative on how competition works and how impugned conduct affects competition. Performance harm can have evidentiary significance, but performance harm is neither necessary nor sufficient. Obviously, it makes no sense to conclude that impugned conduct is anti-competitive whenever it harms consumers. Several significant antitrust decisions hold that. I cite the Rambis decision in the DC Circuit and the Qualcomm decision in the Ninth Circuit. Some advocates of the consumer welfare standard make that point, but they argue that performance harm is nevertheless necessary for an antitrust violation. I argue that performance harm isn't necessary for two reasons. One is that antitrust law maintains a conclusive presumption that competition improves market performance. The other reason is that causation chains are often complex, so performance effects are unclear. The competitive process standard informs how antitrust should approach particular types of conduct. Conduct that serves no purpose other than to corrupt the competitive process should be condemned as per se illegal. To corrupt the competitive process is to preclude actions to gain patronage or to prevent such actions from succeeding. Conduct within the scope of the mother per se rule and little else corrupts the competitive process. Conduct that softens the competitive process merits a quick look at justification. To soften the competitive process is to blunt the incentive to gain patronage or dilute the reward. Competition softening schemes traditionally involve the pooling of revenue or self-taxation. There are cases on point. Most of them find the conduct per se unlawful. Evaluating conduct under the rule of reason should not entail a complex assessment of tangible effects, but rather an inquiry into the principal tendency of a restraint. To impose the burden of justification, a plaintiff should only have to show that the principal tendency of a restraint is to diminish incentives or opportunities to compete. Anti-competitive effects are characterized by the limiting cases of collusion and exclusion. Restraints in the collusion category diminish incentives to compete. Restraints in the exclusion category diminish opportunities to compete. In applying the competitive process standard to unilateral conduct, the critical insight is that antitrust law permits competition on the merits, no matter what its consequences may be. This idea has a long history. The Senate debate on the FTC Act expressed this idea repeatedly. Competition on the merits means striving for patronage by offering value, as opposed to preventing rivals from doing that. So a firm competes on the merits by pricing close to cost, by passing on cost reductions, by improving a product, or by creating something new. Proof of unlawful exclusion, therefore, requires proof of harm to a competitor that was inflicted by competition that is not on the merits. The text of Section 7 of the Clayton Act, in my view, states the competitive process standard, and the courts articulate that standard when they explained how efficiencies are relevant. Courts consistently hold that efficiencies are relevant only to the extent they cause competition to become more intense. Thus, courts reject the Williamsonian trade-off. The competitive process standard also makes clear that harm to competition among buyers can make a merger unlawful. Under the consumer welfare standard, the elimination of buy-side competition can be seen as a benefit because of the partial pass-on of lower prices paid to input suppliers. Some defenders of the consumer welfare standard believe that it is the only source of principle and order in antitrust law, but I see it as a source of much mischief and hardly any principle or order. Some defenders of the consumer welfare standard believe that antitrust should provide a remedy whenever marketplace conduct harms consumers. I believe that antitrust law has a narrow mandate to protect the competitive process, and staying inside its lane solves more problems than the consumer welfare standard. Finally, I want to stress that neither the consumer welfare standard nor the competitive process standard is inherently pro or anti-enforcement. Under both standards, litigation burdens can be allocated and calibrated to the desired intensity of enforcement. Thank you for giving me this opportunity to present my paper, and I look forward to hearing later about the comments. Good afternoon.
Well, good afternoon, everyone. I'm here for the comments. This is a very interesting paper, and I'm glad I had a chance and the opportunity to read it. And in it, as you heard, Dr. Werden criticizes the consumer welfare standard as faulty and proposes a bad alternative, the so-called competitive process standard. And he explains that by means of an old concept from my field, economics, and in particular industrial organization, which is the structure, conduct, performance paradigm. So it's the idea that there are features of an industry that are structured, the number of competitors, their sizes, market shares, and so forth. Then there's conduct, what those firms are able to do within that particular structure. And finally, there's performance, by which we mean the effects as measurable effects, like consumer surplus, like prices, output level, innovation, product variety, and so forth. And his claim is that antitrust policy has focused perhaps too much and too narrowly on effects, in particular output levels, to the detriment of the first and second stages of the so-called SCP, structure, conduct, performance paradigm, meaning structure and conduct. And so it's a call for a principle, the competitive process standard, that would place a greater weight on the first two elements. In Dr. Werden's words, in economic terms, the competitive process standard focuses on market structure and conduct, while the consumer welfare standard focuses on market performance. Now, I am not an antitrust scholar. My field is industrial organization. I'm primarily an academic. I have, in the past few years, worked as an expert witness on a variety of cases, information exchange, mergers, abuse of dominant position, exclusion, both as an expert for counsel as plaintiff and as defendant, but I'm not an antitrust scholar. And Dr. Werden, by contrast, has written many papers, books as well, on the topic. And more importantly, he has decades of experience as someone at the forefront of antitrust policy. And in that sense, I cannot possibly compete with him in terms of experience and knowledge of the history of antitrust in the US and of the practice of it. Nevertheless, I think the perspective of an outsider can at times be helpful, and that's what I can offer to you today, is the perspective of somewhat of an outsider to the world of antitrust in terms of scholarship and thinking about the philosophy of antitrust. So here are my 4 points commenting on his paper and his ideas. First point, I think it's important to distinguish principles from standards. I think a principle that we should protect the consumer's interests is one that we should all agree upon. But principles like that, in my opinion, are perhaps a little too vague. You know, like, be good, do no evil. We all agree with that, but it's not a very helpful set of standards for an antitrust or for an agency or for a court. So we need standards. We need more specific, measurable, if you will, not by measurable, I don't mean quantitatively, but more easily applicable standards. And I think in that sense, Dr. Worden's proposal seems more like a principle than a standard that can be used and applied by both agencies and courts. It's closer to the be good type of principle, which I agree with, by the way. So that was sort of my first idea. Second idea, one size does not fit all. We all agree with that. And what I mean by that in this present context, by the way, there are two senses of this sentence in here. One is things don't apply uniformly to every country. I was just in Budapest last week on a meeting of economists from antitrust agencies and talking about the public interest mandated in the context of the South African Competition Policy Agency. Things are very different in other countries. But in the US, with the very long antitrust tradition that the country has, I think it's a different story. But the other sense in which I mean that one size does not fit all is there are different parts of antitrust, and we have to think of them as different parts. And so collusion and price fixing is very different from merger policy, for example. And I think that the idea of protecting competition by focusing on conduct probably makes a ton of sense when it comes to price fixing collusion. And that's the whole point of a per se rule. Why? Because, it's very hard to think of price fixing as something that's in the interest of a consumer. And so it makes a lot more sense to have very conduct-related standards there. But if you talk about merger policy, do you want to make a merger per se illegal? Or I don't even know how I would go about and using the idea of competition in there other than looking at its effects. How can you not look at effects when you look at a particular merger? So I don't think that one size fits all. And in this regard, I think there's a certain resemblance with the big debate in physics. I don't know if you're familiar with it. I'm not very familiar with it, of the grand unifying theory. It's just sort of the holy grail of all scholars in physics. One will find a theory that brings in the weak force and the strong force and everything, and quantum mechanics and gravity all into one single model. We haven't succeeded at that, but perhaps the right question is, why? Why is that so important? I mean, physics has worked perfectly well with different models in different settings. Why do we need a grand unifying theory of antitrust? I mean, price fixing is not the same thing as merger policy. Anyways, that's my second point. And the third point, perhaps should have been the first point, come to think of it. There's an enormous confusion with words in here, it seems to me. People are speaking past each other. They're creating straw men and destroying them. They're completely disagreeing on about everything. They're not even agreeing to disagree, which is very unfortunate. And I think it's largely because of a confusion in words. What do I mean by that? What do I mean is that the concept of consumer welfare actually predates antitrust. I mean, we're talking about Alfred Marshall, 19th century, the founder, as it were, of neoclassical economics, or at least a precursor of it. This is long before the Sherman Act, before the birth of antitrust. It's a concept that was created completely independently of antitrust considerations. It's simply the idea of measuring economic well-being of individuals, consumers, and society as a whole. What happened then is somehow, sometime, somewhere throughout the 20th century, I suppose Dr. Werden is right, Robert Bork had a big influence in that. The concept of consumer welfare was captured, if you will, for lack of a better term, by the Chicago School and kind of warped out of its original shape into a very specific perspective on antitrust, which is somewhat narrow, I would say probably very narrow, and focusing on one measurable, which is output level or prices. Given the law of demand, price and output, they go together. So one of the two, as not necessarily the single measurable, but certainly the main measurable and the one that people use the most frequent. In my opinion, it's one of those instances of the drunkard who's looking for the keys under the street light, and they ask, is this where you lost your keys? No, I lost them on the other side of the street, but at least here I have some light. And meaning that there's an enormous bias for focusing on one single dimension because it's easier to measure. Not easy, but certainly easier. So when people talk about the consumer welfare standard nowadays, they largely refer to a very, very specific approach to antitrust that's very closely connected to the Chicago School. And in that sense, I think I completely agree with Dr. Werden, and I agree with most economists that he will talk to in saying that that's been largely disproved as a correct approach to antitrust. It's excessively narrow, and at least since the 1980s, a lot of economic analysis in my field of study, industrial organization, has largely shown that the principle that if it's good for firms, it's good for the world, is not necessarily true, and that there are other dimensions other than price level or output level that matter in terms of effects. Interestingly enough, Carl Shapiro has been one of sort of the leading economic experts in the field of antitrust. I believe in the context of, I think, some Congress hearings or something like that, he proposed the protecting competition standard, which is actually very similar in terms, even in words, to Dr. Werden's proposal. And then as a subtitle, which I think is very interesting, he says, my proposal corresponds to the consumer welfare standard done right with better name. So there you go. There's a big confusion about words. We all agree that it's important to protect consumers, to protect the economy, society, and the competitive process. We use different words to express it, but at the end of the day, I think we are all in agreement that the consumer welfare standard, narrowly understood, how it is now currently understood, which is very narrowly, is not appropriate. That leads me to my fourth point, which I could title Against the Neo-Brandisian Approach. Dr. Werden did not talk a lot about that, but I think that's where a lot of the discussion is nowadays. I would say the major difference, so one thing that we all have in common, Neo-Brandisians, most economists, Dr. Werden, Carl Shapiro, et cetera, is that the consumer welfare standard is at times, or frequently I might say, unnecessarily narrow in the way that it's been applied. I guess that's the extent of the agreement. But then what most economists are opposed to is the alternative that's proposed by Neo-Brandisians, which is a mandate for competition agencies that goes well beyond the idea of competition, the idea of the competitive process, the idea of consumer welfare, and into a lot of other things, which include inequality, freedom of speech, political power, you name it, depends on who's talking about it. And that, I think, is a mistake, if you ask me. I think it's a mistake because a narrow mandate, I think it's a crucially important feature of an antitrust agency, of any agency for that matter, because of its legal predictability, which is very important, agency commitment, which is also important, and ultimately accountability as well. Exhibit A for me is central banks and monetary policy. Yeah, you know, the current president saying that, oh no, you're not, maybe you should lower interest rates because it's important for economic growth. Listen, that's not my mandate. My mandate as a central banker is to keep inflation in check, monetary stability. That's my shtick. That's what I do. Don't try to broaden my mandate. And I think that antitrust is a little bit like that. We're not going to solve all of the problems at once. Let us try at least to be good at one, of keeping markets competitive, applying the law, as the commissioner earlier said, and sticking to our narrow mandate that people should know what it is, and courts should know what it is as well. So don't throw the baby out of the water. Just to be clear, what's the baby, what's the water in here? The baby is the idea of the competitive process of protecting consumer interests. The water is the fact that the current standard is perhaps unusually narrow in not including or not providing enough weight to dynamic elements, to entry, to innovation, and things like that. We all agree with that. But let's not throw the baby out of the water and making competition agencies, antitrust agencies, is kind of a free-for-all. So in conclusion, I think this was a great paper. I enjoyed reading it, and I do recommend it. I think there's a lot of confusion regarding the term consumer welfare. I think neo-Brandisians, Dr. Werden, and most economists are very critical of the narrowly interpreted Robert Bork-induced consumer welfare standard. That said, we disagree on a number of issues, and my position on that, like I said, is that let's keep the mandate of antitrust agencies narrow. Let's improve the way we apply the law, but let's stick to what we have been doing and what we know how to do. Thank you.